And now I would like to introduce today's speakers. Chris Dang is a member of the firm's Health Law Group. Chris assists clients with regulatory compliance issues, including corporate governance, mergers and acquisitions, vendor contracting, operations, Stark and anti-kickback compliance, HIPAA, and state medical record/privacy requirements, FDA and DEA compliance, and labor and employment issues. Chris represents pharmacies, pharmacy benefit managers, third-party administrators, discount medical program organizations, drug and device manufacturers and wholesalers, physician practices, and other players in the healthcare space. His work involves working hand in hand with in-house counsel, business, compliance, and operations teams. Our other speaker is Nick Meza, who is an attorney in the firm's Health Law Practice Group. Nick's practice includes assisting retail, specialty, and long-term care pharmacies, pharmacy benefit managers, and wholesale drug distributors with regulatory and transactional matters. Nick also advises healthcare providers, physician and practice management groups, and healthcare software developers with a variety of issues, including general, federal, and state regulatory compliance, anti-kickback issues, telemedicine, telehealth, and telepharmacy, defending against and responding to regulatory complaints and investigations, and HIPAA privacy and security rules. And now I will turn it over to Chris.
Thanks so much, Kim, for that introduction, and welcome everybody. Good morning or afternoon, wherever you are. My colleague Nick and I are so glad that you could join us today for this BLT training. It's a hot topic. It's an important topic because of the size and scope of the industry. We've got a lot of ground to cover, so we'll get into it. A little bit later on, we'll be joined by our National Practice Chair of the Health Law Group and the leader of our Healthcare Transactions team, Amy Cotton-Peterson. So without further ado, let's get into it. Why healthcare? Why is healthcare such a dominant force and at the top of mind for folks, whether you're actually in this space now or working tangentially in it or want to get into it? Well, if you think about it, close to 1 out of every $5 spent in the United States, so roughly 20% of our GDP is spent on healthcare. As you can think of in your own personal experiences and lives, healthcare touches everybody, and you're going to need it sooner or later, no matter how healthy you are, no matter how your family circumstances are, you or somebody in your life will require it at some point. That kind of universality of the product, right, unlike cell phones and iPads or fancy sports cars, makes the demand somewhat inelastic to a point, right? Because the demand is so broad and diverse, people will tap into the system, and because it is literally life and death sometimes, cost point is no matter. So we see it as a very strong sector of the economy. It's resilient in downturns, and there are so many lines and avenues into providing those services that there is a product or an item that will touch on everybody, from primary care and your primary care physicians to your cholesterol or pain medication. There's specialty care for those who have unique needs, emergency, rehabilitation, long-term, and end of life, and everything in between. There's a spectrum and a touch point for it. And from there are also service lines in industry, such as insurance, pharmacy benefits management, discounts, that all support and feed into that line of support in that sector of the economy and the services that it provides. Historically, there's also been a strong trend in core institutions and business lines, and you see it in large mainline hospitals. Well, rural hospitals are somewhat of a different animal sometimes, unfortunately. Insurance and pharmacies as sectors that dominate the healthcare space. There's also opportunities for integration in order to coordinate care. So you see a lot of times now the industry trying to consolidate and wrap things up in order to provide better care. So large insurers purchasing PBMs, specialty pharmacies to take care of their clients, hospital systems working hand in hand with practice groups and laboratories, with insurers to coordinate care, that sort of thing. So there's a lot of opportunity for innovation and configuration in the space, simply because it's so large and such a wide network. There are, of course, challenges in the healthcare space. Traditional hard science is rooted in time and research and development, which costs money. It's not every day that there's a new surgery, procedure, drug, or therapy out on the line. True hard medical science takes sweat and time. So advancements there take a lot of money and investment, and there's opportunities as part of transactions to acquire IP rights or developmental rights that we'll talk on a little bit later. But that's an important aspect of a challenge that the industry faces. There's, of course, a lot of insurance that dominates in healthcare, and part and parcel to that is not only delivering care but cost control. So within the insurance space, there's some rigidity. There's also opportunity for innovation, but we're always going to be in some way, in a lot of the healthcare sector, tied to and working with insurers to get items paid for and reimbursed under plans. There is somewhat a limit on demand when cash is involved. We see this sometimes in drug pricing and in the news of late, where certain generic drugs or manufactured drugs have increased in price over time, which eventually causes public concern or consternation. Same thing with various healthcare procedures. We all know the stories of that multi-$1,000 surgery or hospital stay bill that shocks people, but there's avenues where that is oftentimes worked out through insurers or providers as well. We have a regulatory landscape that is old. It's for the practice side, a lot of times rooted in the police power of the state governing the practice and behavior of individual professionals. On the federal side, it has a lot to do with access, IP, drug regulation and approvals. And these institutions have been around for almost 100 years in some cases. And there are elements of it that are slow to change. Of course, in the payer and reimbursement space, there's some very dynamic behavior as well as administration changes occur, national priorities or healthcare priorities change. So there's dynamic aspects as well. Lastly, we have the Uber of healthcare, right? We've heard this term used and applied time and time again. I want to be the Uber of healthcare, of pharmacy, of medical practices. And there's plenty of great innovators out there pushing innovation to try to meet some of the challenges that have always been faced by an old storied institution of healthcare: access, availability, ease of use, communication. At the same time, these types of entities can run into the old structures that we just talked about in terms of the regulatory landscape, where government regulators are not as quick to change regulation and behavior. And because no healthcare provider really operates in a vacuum by themselves, they quickly run into, say, regulatory governmental issues or payer relations or frameworks in terms of FDA or approval or DEA regulatory compliance. So there are innovators and great innovators out there pushing the boundaries, but at the same time, they also need to be cognizant of those regulatory boundaries. And with that, I'll turn that over to my colleague, Nick Meza, to kind of introduce the landscape of the transaction environment.
All right, thank you, Chris. And to the extent possible on a webinar and that's being broadcast nationally, and folks' laptops, please do try to pipe up. We're looking here to see if you have questions online. But what I want to start with really, and it seems really basic, but When you're dealing with the healthcare space, it's really important to ask those essential questions of who, what, where, when, and why. And understanding the nuances and answers to each of and every one of these questions will really help to form our understanding of the deal, how the deal plays out, the players that are involved, and of course all of the regulatory implications that are tied to the deal, given whatever business we're dealing with. So what we've tried to do here is really structure this from a very high level to implicate all manners of healthcare entities, from hospitals, physician groups, pharmacies, insurers, and the like. So with that, let's dive right in. Again, it sounds like Deal 101, understanding who the players are, but again, in the healthcare space, the experience level, when you're talking about whether it be a buyer or whether it be a seller, can vary tremendously. You might, for instance, be dealing with a buyer that has a lot of experience in the healthcare space. They know exactly what they're going for, and they understand the regulatory implications at play. You might, on the other hand, have inexperienced buyers. And obviously, as counsel, there might be a lot more educating of that particular client, or if you're on the other side, educating that other side with respect to the regulatory implications at play. The same goes with sellers. You've got experienced sellers, and scary enough, you've got inexperienced sellers who might just be hanging on by the seat of their pants, running a business in this highly regulated space. What we are seeing a lot these days, and it's an interesting twist to the healthcare world and deal, is really the entry of private equity into the healthcare space. More and more, we're seeing private equity firms that actually have a decent amount of experience and understanding of the healthcare space. On the flip side, we will see private equity that it only sees the returns, right? And so really it doesn't understand what they're getting into. That's the same with insurers and lenders as well. Why this is also important is when you get down the road to changes of ownership, licensing of these entities, there are in some states very, very stringent ownership disclosure requirements that require ownership be disclosed all the way up the chain. When private equity is involved, obviously that can be a very troublesome issue. We've had multiple issues out of California where there's a private equity firm that seeks to acquire a healthcare entity, and the regulatory board requires disclosure all the way up the chain, including the social security numbers of the owners that are involved, right, that are at the top. We dealt with an instance where one of the members of the private equity was essentially a national sovereign wealth fund of Australia. And we had to have multiple calls to inform these regulatory boards, which oftentimes are not that sophisticated on the deal side either, that, hey, you're essentially asking for information for folks in another country who don't have social security numbers, that the numbers are in the millions. So we told them we could show you on a map where it is, but it's just really not going to be very helpful for you. So again, understanding who the players are, their experience level, is very important. And I think we've got a question. We've got a question. In what context are you talking about buyers? In-house, HR department that want to purchase healthcare insurance programs for their employees? Chris, do you want to add something to that?
Yeah, no, in the context of what we're talking about today, and very well be, you could have a context where you're an employment benefits administrator wanting to purchase particular healthcare for your employees, but really we're talking about healthcare institutions wanting to purchase full line institutions that are their peers or competitors, getting brought onto new business lines, like a drug manufacturer wanting to purchase perhaps a drug discount card administrator. So we're really talking about business-to-business type of transactions and purchases, not vendor-type purchases. But you would also exercise, of course, scrutiny, the same level of scrutiny in some cases on the purchase of major vendor services if you were acquiring healthcare services for your organization as well.
And to that point, we're also talking about sellers in that space as well, right?
Yep.
So hopefully that answers your question to the gentleman or madam online. Also, again, touching on experience, it's also important to understand that oftentimes experience in this world can cause hiccups. If an acquiring or selling entity has had issues in the past, it could often hang up deals, right? You're arguing about issues that you dealt with in the past and that you believe might occur again in the future. So it's kind of a double-edged sword. You might be dealing with experienced counsel, and that could be a good thing, but it also could hang up a lot of the process of the deal itself. So again, a very basic concept of understanding who's involved and what it is that we're doing. Again, another common sense question, but it's important to know, in advance and have a clear picture as counsel, what is it that's being bought? What is it that's being acquired? Are we dealing with, this is kind of piggybacking off of what Chris was saying, a single business line? Are we dealing with a healthcare provider? Is this a vendor, or are we dealing with, more of assets or services on the payer side? I guess it's also very, very important to understand, and we've dealt with this before in the past. It's something you wouldn't think would occur, but a company comes in seeking to acquire perhaps an entity that they believe has nothing to do with healthcare whatsoever. And we've dealt with this before. An entity comes in, they want to buy a large retail operation. Come to find out, really before it's too late, that this operation also has a national pharmacy chain as well. So of course, that changes the entire makeup of the deal. We're now dealing with, intense diligence on the healthcare side. Initially, we thought we were dealing with a retail operation. And so really having a clear picture of what might be involved. Also understanding that certain entities may have multiple lines of business that have various implications on the regulatory side. I think a hospital is a very easy example of that. Obviously, there are facility licenses at play. There are the hospital might have a pharmacy or laboratories that have additional licensure involved that are governed by different bodies. And so again, understanding that as well is very key to moving forward with the deal. What type of deal is it? I think it's fair to say that with non-healthcare deals, we really see more asset acquisitions, right? They're much more common. And stepping back again, Deal 101, with the stock sale, obviously, there are advantages and there are disadvantages. In the healthcare side of things, this may be the best option for continuity of business operations, right? Depending on the provider type, the percentage of ownership at play, the licensing issues. What we see here is that with stock sales, obviously, there are a lot of contracts at play, payer contracts. When a entity acquires another via stock sale, more times than not, there's a continuity with the payment process. However, obviously, the downside is that you're assuming all of the liability of the entity that you've just acquired, right? And it's considerable liability, or potentially very, very considerable liability. We're talking False Claims Act liability, criminal anti-kickback liability, and HIPAA. So you kind of have to weigh that. And as counsel, obviously, we talk to our clients about the pros and cons of a stock versus an asset sale. with respect to licensing, there might be more of a seamless transition as well when you're dealing with the stock sale. Asset sales, the flip. Obviously, you discharge the liability, but more times than not, what you're dealing with is a change of ownership by definition of whatever that means within the statutes or regulations that govern that entity, whether it be a hospital, a pharmacy, an ambulatory surgery center, and the like. So it's really important to understand that. Obviously, mergers have kind of the same vein as stock. You may be able to kind of more seamlessly bring in the business, but you're also bringing on the liability of that business as well.
And Nick, I think it's important because we have some folks here who aren't normally in the healthcare space, but to talk about why this is important for healthcare providers, right? As I alluded to earlier, healthcare providers and entities in that business typically don't operate in a vacuum by themselves. And so while you normally see in a lot of their business lines and industries, asset purchases being the order of course, right? Because you don't want the liabilities, you want to just pick up the asset and move forward and go on. The interplay of a healthcare provider entity, say a hospital, is rooted in its not just the physical building and the equipment inside it, but its relationship with its payers. So insurance companies, be it commercial or governmental, who pay the bills at the end of the day and reimburse the facility for treating that hospital's patients, right? Those insurers will pay for the treatments for their membership and lives covered, but also that hospital's licensure, which goes from the actual licensure of the hospital itself to the radiological control licenses that the hospital has in terms of its X-ray equipment, to its pharmacy license, to down to its caterer and gift shop. And so a hospital isn't something that we can just close overnight and move, change the signs. That requires interface with so many other players. And of course, we can't very well kick out folks overnight while we kind of redress the hospital to move forward. So that's where stock and mergers are much more prevalent tools in the healthcare space because of that interplay.
Right, and I guess that begs the question: why consider an asset sale, though, too, in the healthcare space? And typically, we see that when there has been via diligence, you've discovered that there's been some really significant liability or liability creating event that has occurred where we need to discharge that liability. There also might be some very serious tax implications as well to transition or structure the deal as an asset sale. Asking where, understanding really the physical location of the business. Sometimes this is very easy. You might be dealing with just a single physician's office. Where it gets complex is where the deal involves locations across multiple states, again, that have multiple business lines. So a key example might be a pharmacy, right, that has 5 pharmacies, pharmacy chain across 5 states. Assuming they have operations and they are shipping into each of the 50 states, you've got federal licenses involved, obviously state licenses involved. You've got potential contracts with Medicare and Medicaid in multiple states. And so at the very least, you're dealing with 300 plus licenses, permits for just 5 pharmacies, right? Again, that have operations in multiple states, because you have to acquire the resident pharmacy permits, the non-resident pharmacy permits, and all the other ancillary contracts and permits that are tied to that. So really having a clear understanding of what the business is, where it's located, and oftentimes, where are the clients, where are the customers. If you're dealing with a telehealth or a telemedicine practice, or, for example, services that are being performed by a nurse in one state, making outreach to a patient in another state, does that outreach constitute the practice of nursing or the practice of medicine or the practice of pharmacy into that state that would trigger licensure requirements that we need to look out very closely in diligence? So again, these are all very, very simple questions, but they are simple questions that really have enormous impact on the deal and the success of the deal moving forward. So timeline, those who are obviously in this space, and Chris will get into really the specifics of each of these later, and we should actually probably have diligence right in between the LOI and the sign component. But we wanted to bring it up because, oftentimes in regular transactions, we have a sign and simultaneous close. In the healthcare space, it's much more common to have a sign and close period, and that period we recommend, and I think it's becoming the norm, to have a 60-day sign and close. We see 30. I think we've dealt with a 10-day, even closer, a 1-day sign and close, and that can be a nightmare. And the reason in the healthcare space why that matters is because regulatory boards require advance notice of a change of ownership. That advance notice can be 30 days, sometimes 10, sometimes it's post, right? And so it's really important, especially when you're dealing with folks in the business who want to have a short time frame, to really convey the importance of building in, if you can, some time for a sign and close to allow for the proper notice and obtaining of new permits. Because at the end of the day, if you don't have those new permits or licenses to conduct this business, you have to stop. And if you don't, you're operating in violation of whatever state or entity's regulations. So it's really important to understand the time frame and build that into your analysis. And this is kind of the common sense one, and it should actually probably be as counsel, outside counsel, this should probably be the first question we ask, right? Is why is the deal important to the client? What is the client seeking to do? Are they expanding? Are they consolidating? Are we looking to add a new line of business or creep into a new market? So I think that's something that obviously we try to do, is really understand the business and where they're going and the purpose of the deal moving forward. So Chris is going to get into the particulars, and yeah, I will be back. Yeah.
Thanks, Nick. So this next phase, we're going to talk about some of the actual mechanics of the process. And I know a lot of the folks are on the line and on the web have some experience in deal mechanics. Obviously, from prior work, there is a particular bent towards healthcare transactions that we want to make sure that we discuss as well. I also work to provide some context to some of the acronyms that we're tossing around and why they're important and why there's such a unique nature and flavor to healthcare transactions, which really, really kind of demands subject matter expertise from your counsel, hint, hint, Quarles and Brady. But let's just talk about, the lay of the land here, just a brief overview. We're going to get into each of these, and again, the unique flavors of healthcare transactions. Confidentiality, this is going to be important across the board in any transactions, right? Whether or not you're dealing with publicly traded entities or private equity and private holdings, this is going to be a serious issue, and we've seen it before. There's SEC obligations, prohibitions on insider trading that we have to ensure that we keep the proposed transaction silent or confidential. So be it from large drug manufacturers and pharmacies to hospital systems that are private but commercially traded on exchanges. It's going to be critical to maintain that confidentiality. And this is a serious issue. We have seen it before, and others surely have as well. There are occasions where the SEC may come in and knock in and ask, hey, who knew when and what? And in investigating insider trading situations, and they'll get down to the nitty gritty of asking folks, in your firms and consultants, hey, when did you find out about the deal? And of course, perhaps did anybody who knew in that chain act on that insider information before it went public? Just a fun part to note, a lot of the players obviously choose code names or deal names in the transactions. It's always helpful to choose a fun one or a memorable one, because that's sometimes the only joy a poor associate gets in a deal, just a fun transaction name. Next, we have the LOI, exclusivity, and non-disclosure agreements. This, as many of you know, kind of just establishes the dating relationship between the parties, how long we're going to go steady for, and that we're not going to tell each other or post it on Facebook until and share our secrets between ourselves or use that in an inappropriate way later on. Important in the context of non-disclosure and confidentiality as part of the actual deal process itself. A lot of times, as I'm sure folks have seen online, there are occasions where people who are competing in the same space want to talk about mergers or a transaction or a hostile takeover. In that case, if you show the other side what's under the hood in order to allow them to perform due diligence, there's concern that that information may be misused or misappropriated. And in those cases, right, it's important to establish the boundaries of the due diligence process, who is allowed to look at what, how is that information compartmentalized, not just on a, hey, human organization factor, you only look at this thing and I'll only look at this thing, but also actually structurally design the due diligence to have clean rooms and clean compartments inside the data room, to have only outside counsel look at this specific segment of information for this specific purpose, and then of course not relay or share documents if they're not permitted to do so with either the purchaser or seller as the representation may come. A lot of times at this stage as well, we'll get familiarity with the actual target or that's going to be subject to the transaction. The seller is going to put together a confidential information memorandum, or if you're representing the seller, you may assist with that CIM or SIM. There'll be a PowerPoint presentation, a layout, organization chart information that says, hey, this is what you're looking at, right? There's like doing your research and specifications on a new model car. Here is our business. Here's what we do. Here's an overview of our operations to give the buyer and seller teams full context as to what the seller is pitching, and of course the buyer as to full context as to what they are looking to purchase. And like any due diligence and transaction process, we're going to get into due diligence, and that's going to start off with a due diligence request list. I'm sure folks who have ever been involved in a transaction attending have seen a due diligence request list, have put one together, and most law firms, corporate or business law teams have a common template one they use. Maybe they swap out if it's a publicly traded entity or not, and some sort of state-specific issues or not. But more often than not, every time I get a due diligence request list, and I think Nick can attest the same, that is just prepared by corporate counsel, business law counsel, we always usually end up doubling it in size because there's so many specific healthcare, regulatory, and operational nuances in any space you have, right? I think earlier I used the example of a hospital, right? A hospital is, of course, in part a business with P&L lines and business obligations and contracts, vendors that it's servicing and employees, tax obligations. But that hospital also has obligations to its payers, again, governmental and commercial, right, where it gets most of its money at the end of the day from reimbursement. It has obligations to the state in terms of its licensure. It has obligations with respect to its credentialing from the hospital itself down to maybe its trauma status level and how it operates. It has obligations interfacing with other healthcare providers. Its relationships with other healthcare providers are regulated by Stark, an anti-kickback statute, which prevent hospitals and physicians from exchanging remuneration for quid pro quo arrangements. Hey, I refer my patients to the hospital. Hospital, you give me a little bit of something or payment on the side. So those types of relationships are highly regulated, if not outright prohibited civilly and criminally. So that's just one example where, again, thinking of the business acquisition or business sale of a target entity in the healthcare space really does require subject matter expertise to get down to the bottom of the specific provider or supplier's operations. Another example is pharmacies, right? You would think of your normal retail pharmacy on the corner of Walgreens, Walmart, CVS. You can imagine just hey, there's just it's a simple retailer, right? Well, behind that retailer again are all of its payer relationships, governmental and commercial. There's licensures. Say that if that pharmacy is servicing folks in that individual state, they'll be licensed in that state. If that pharmacy has mail order services to other states and potentially 50 states, you may have a number of licenses there. If they're doing compounding, is it sterile or non-sterile, right? Is it basically for non-sterile compounding, something that you would just put on your skin that's low risk or ingest orally, it's low risk. But if it's injectable or infused into your veins, there's a lot higher risk for infection. So, if you're buying a pharmacy, are they doing that? Are they meeting the USP 797 and 800 compliance, right? Now I'm just tossing out the lingo out there, but there's a lot of individual nuance there that needs to be accounted for in the due diligence list and those requests, because that will save the parties time as they go through the diligence process in asking for that pinpoint information, which is so very critical. Want to talk briefly about the virtual data room. Both sides can save a lot of money with the right features, and I want to emphasize this because large transactions can rack up the bills, unfortunately, fast just due to the sheer manual labor that has to occur in things. So data rooms where folks exchange information, right? The seller posts certain information in response to the due diligence request lists. Buyer may also post some information about themselves in response to the requests of the seller. That has to be well organized. It's a living data room. It's a moving target because folks can only collect information in a linear fashion, and it takes time. And so that data room will probably populate over time, and depending on the nature and tempo of the deal, may require diligence to start moving on whatever pieces are in place currently. And so it's important to have a data room that's well organized, that alerts users of, hey, these are the new items that are popped up for your review. That way we're confident in that each of the documents are appropriately reviewed, searchable and well labeled. Many times we've seen just literally numbers in the data room that don't correspond to anything, but the file, where it was inserted in the file, and of course that doesn't help anybody and racks up costs needlessly at the end of the day. It's important in a due diligence process because there's often many players at hand, right? Buyers and sellers counsel. Even the buyers and sellers may have multiple counsels, one corporate counsel and sometimes separate health law counsel, separate fraud, waste, and abuse counsel, separate insurance counsel. And so it's important to establish a well-defined division of labor, management of that division of labor, and communicating among all the moving pieces. There's also outside consultants at play. For instance, again, going back to the hospital example, a buyer may want to bring in an independent credentialing auditor to make sure that the hospital's meeting its credentialing obligations. Similarly, as a purchaser of a pharmacy, you may want to bring in a consultant who specializes in retail or sterile compounding to ensure that to get boots on the ground and look at the actual environment of what's going on with some subject matter expertise to understand what's going on. There's also the due diligence report and what will ultimately be provided to the user. So just thinking going forward, think about who the audience is, what it'll be used for. Ultimately, it may be the only document that is used at the end of the day, and to capture everything that was looked at and is provided to in-house counsel after the transaction is complete. So it's important to have a great document there. Just a quick overview of the diligence phases, but the ultimate objective is to find the ghosts, manage them either financially or through indemnification or a combination of both, or walk away. So like any other transactions, as we get into the details and the nuts and bolts here, business reviews and financial reviews are par for the course for any type of acquisition or sale. You get to know the lay of the land, the people who operate it, the sense of operations. A lot of this will come from the Confidential Information Memorandum, the SIM. You have financial review to review the health and sustainability of the operations, its compliance with your traditional obligations, be it if it's a publicly traded entity or if it has accounting obligations, and the valuation. It's important to note on a key difference here in healthcare is that not only will you have your normal business financial obligations on accounting principles, perhaps as a publicly traded entity, but if you're, say, in the insurance space or the pharmacy benefits management space, you may have to have minimum cash reserves to meet state insurance obligations, bonds in place, for continuous coverage, that sort of thing. So again, important twists on the healthcare space there. An important aspect of healthcare transactions due diligence is the contract review, right? As we said before, that healthcare providers don't act in a vacuum. They have relationships with payers, insurers, commercial, private. They have vendors, multiple vendors, sometimes, as in the case of the hospital, from everything from outside physician groups that provide call coverage to caterers, medical equipment and device suppliers and cleaners, power, light, electric, real estate. It's important to understand where the money is coming from and going to, not just because of assessing the assets and liabilities of the practice, but again, healthcare providers' relationships with other vendors are highly regulated. So I touched on briefly Stark and anti-kickback statute. These, to get a little bit more detail, these two principles apply to many healthcare relationships, and at the end of the day, say, hey, as a provider of services, I can't give you money or remuneration, things of value, be it tangible, intangible, direct or indirect, for the purposes of generating me business or sending business to me as a quid pro quo. And likewise, you can't ask for it and should not ask for it because you're in a position to send me referrals. And while it may make sense, absolute sense in normal business context, these are important principles and guiding lights in the healthcare space, because what the government wants to do at the end of the day, if it's as part of Stark or anti-kickback statute or state fee splitting or professional laws, an ethical obligation on it, they don't want a relationship between providers to be undermined by financial incentives between the party ahead of patient care. So that's why those exist, and that's why that lens has to be overlaid by much of the review across the contract and vendors and relationships.
And I think, Chris, it's also important to note, obviously, you could do a wholesale review of, the four corners of every contract that the target or has entered into, but oftentimes operationally things change. So that's where it is critical, obviously, to oftentimes do an on-site review, or you really talk through with the business what it is that whatever service is being provided, how that's been operationalized, how that's changed from the initial contract. to truly understand kind of the risk profile.
Absolutely, absolutely. Lastly, as for any other due diligence process for when it comes to contracts and relationships, we're looking to whether or not that business line is sustainable, right? If we choose one selection of a transaction modality, right, like a stock or merger, are we going to be able to port that business over, or are there specific requirements because of cost control measures by insurers or the state, or conditions of participation that they've overlaid? Would that disrupt the business? For example, California had a moratorium on new Medi-Cal, which is California's Medicaid provider, for a period of time. So if you had swapped owners, you would disrupt that company's ability to operate in the state of California, or in many regions, or in certain areas of California. Obviously, that's something that you would want to know if your transaction will disrupt that line of business. Another important aspect is regulatory review. We need to know the regulatory topography. Again, it's going to be specific subject matter expertise that's going to come into play, be it a hospital, pharmacy, practice group, laboratory. We need to understand the practice and operations and the boundaries of what they've been doing. Have they been operating compliance, right? Is that telemedicine group writing prescriptions and interfacing with patients in a way that is lawful in the 10 or 50 states they're operating in? Are they engaged in business development marketing that complies with Stark and anti-kickback statute, or have they exposed themselves to potentially criminal or civil liabilities by exchanging items to curry favor, from everything that we've seen from kitchen equipment to expensive lunches, hotel arrangements, that sort of thing? Look into that dynamic as to the business development marketing relationship. Are they meeting their third-party obligations, governmental and private, to their insurers, the payers, or the governmental entities that pay them? Do they meet at the end of the day, the obligations that they must meet? And those vary from intellectual property to, if you're a drug manufacturer or a pharmacy, Federal Food and Drug Administration requirements. If you're a distributor, in particular controlled substances, the drug enforcement agencies requirements. Again, fraud, waste, and abuse, which is that overarching term for Stark and anti-kickback statute. Their accreditation and certification requirements in order to use certain representations that, hey, we're a JACC hospital or a URAC accredited pharmacy. Those are all important areas to inspect. And again, subject matter expertise is absolutely critical.
All right. Thanks, Chris. So how are we doing on time? Damon, I think we're about, 10, 15 minutes left? Okay. All right. So we've got a number of slides. We'll try to be as efficient as possible. One of the key areas, and I think we touched on it before, is obviously the review of licenses, right? From entities, licenses to personnel. That's really a main thing that we focus on, certainly, to ensure that if we're talking about physicians, that folks are have an active license in good standing. Are they on any federal exclusion lists that might prohibit them from participating in government healthcare programs and the like? So it's funny, and we put in here your license and registration, please, but there have been multiple deals that we've been involved in where an entity is essentially operating an entire business line with millions of dollars of revenue without appropriate licensure. And we discover that in diligence. And it's a simple task of telling an entity, give us every single one of these licenses or permits that you might hold from federal, state to other issues like accreditations and the like. So they could be as nuanced as shopkeeper permits out of Washington, I believe, where if you're selling over-the-counter drugs, you need to have this permit. So if a, for example, gift shop in a hospital is operating with or without that, is it active? Have there been any gaps in that licensure period, which could have very, very serious implications? For example, if you're participating in Medicaid or Medicare, and you weren't appropriately licensed during this time, and you were billing one of these government entities, you potentially have false claims liability, which could be millions and millions of dollars. So it seems like a no-brainer, but it's one of those key issues that we really focus in on to ensure that the operation is in good standards. Oh, Chris, is you?
Yeah, so I think Nick and I can go over some examples real fast of lessons learned and unique to the flavor of the healthcare space. But people and how they behaved, unfortunately, really do matter in the healthcare space. With so many reporting that you have to do in order to get credentialed or obtain a license in the healthcare space, be it as an entity, business entity, or as a individual human being, your prior criminal and civil history does really impact the analysis of regulators or insurance companies as to, hey, we want you as part of our credentialed network, or we want to give you and grant you that license. Individual criminal behavior way back in college, or most recently, or directly tied to the prior business, really has an impact there. So that may factor into whether or not, hey, we want this person to continue to come over with the company after the transaction, or maybe we give them an out and a buyout package. Fuzzy math has occurred on occasion where the representation of a company as to its certain valuation is not true in the end, or the recent ebb is much more so than anticipated. So that may affect the valuation of a company. We talked on a couple of examples before about breaches in contract and your obligations to third parties, Stark and anti-kickback statute, and fraud, waste, and abuse. People learning through due diligence, learning that they had not marketed properly or not stayed within the boundaries or confines of the various safe harbors or exceptions that are out there, and then having to deal and manage that potential exposure. Fundamental practice compliance, ensuring that you're meeting the boundaries of the area that you can operate in. Medicare and Medicaid gaps or other gaps when it comes to commercial insurance, not meeting your re-enrollment obligations or re-credentialing obligations, can not just provide or mean, hey, we don't have a secure line of business there. It means we may be due and owing back some monies because we weren't properly credentialed at the time when we provided those services and billed for them. Nick, anything else to add?
In the interest of time, no. So after we're done with the diligence period, now it's chow time, change of ownership, and this should really start as soon as possible, right? I touched on this previously. Many regulatory entities require advance notice of a change of ownership. Where we run into a lot of issues, obviously, are folks in the business who may not necessarily understand the timing requirements that are involved here. You run into a chicken and egg type of scenario where you've got a deal that will not close unless the target obtains all the necessary permits that are required for new ownership. Well, that sounds great. However, we run into issues, and we see it a lot, very frequently actually, where a board will not issue permits unless the deal closes. So you're running into this kind of issue, and I think that is key. A key component in dealing with that is, one, explaining that to the business, understanding or helping them to understand the issues at play, and building in closing conditions that recognize that fact, right? So instead of having a closing condition that realizes the issuance of a permit, instead build in something that has, you've obtained a reasonable assurance from a regulatory entity that the permit will issue either on the day of close or the day, 2 or 3 days after. We've also seen instances where we've built in a schedule into the reps and warranties where certain applications need to be filed by a certain deadline, that would meet a closing condition. So structuring the agreement to recognize that a lot of boards, a lot of regulatory bodies will not issue these permits until it closes. So I think that's really a key thing. We run into this probably on every single deal, and it gets very, very messy. One final thing that I will add, I think this is why it's very important to have counsel that obviously recognize this, that understand it, but also have relationships with individuals at regulatory bodies to help either push things through or, to understand and convey, when a deal might close and moving forward with that particular aspect of the deal. So, Chris.
So at the end of the day, right, we get down to the actual agreement itself. And just to quickly cover these important topics, right, your due diligence process, with your subject matter experts from lawyers to outside consultants is going to give you the list of the ghosts. We need to manage them. So are we going to, did we find criminal or civil liability that we want to manage by carving out that line of business? Are we going to reconvert the what was a stock sale or merger to simply an asset purchase in order to limit our liability? Of course, we're going to talk about everybody's favorite topic, money, and the valuation and how that may be affected based on what we find in diligence. We're going to also key in on the survival and look back on some terms and representations of warranties. Hey, we're going to represent our line of business that it was compliant in this certain respect, absent certain disclosures that we have come to known, and stand by those. Lastly, we're going to make sure that we set perhaps a financial cover, so in the form of indemnity, either as a capitated indemnity or perhaps segmenting it into a basket where perhaps the seller will assume $100,000 of the first line of liability if they're incurred on some of the behavior that we saw before, with the seller taking care of the remainder above that. It's important in just to reflect real fast that it's important here to have subject matter expertise in good healthcare counsel, because you'll have a better understanding of what are the true limitations of what we can do in terms of representations and warranties, indemnity, right? There's no healthcare provider under the sun that is fully compliant every single day of every single year. So there are natural limits to the industry as to what people will tolerate. And so again, having experience in the area is so very important. Everything else is kind of largely follows what occurs in other transactions. Again, as Nick discussed, we may have a longer time between sign and close to handle all of the mechanics of these topic areas, from insurance and making sure contracts port over or can be assigned if possible, and obtaining those consents to the licenses, just to ensure continuity of operations. And then post-close, there's some tasks to clean up as with any transaction, and ensuring that what we set out before is all met and tidied up. With that, we'll change over to question time. We've got a little bit of time left. Of course, the formal programming will end here at officially at 12:15, but Nick and I will be available for a little while longer if you want to ask questions.
And we are also in the presence of greatness. Our National Healthcare Group Chair, Amy Cotton-Peterson, is here to answer any questions you might have as well.
And with that, I think we have a question online. What are we seeing with the changes in tax law with asset sales versus acquisition? How are managing the offset of the tax consequence of an asset sale for the shareholders? I will say we're not tax lawyers per se. We have
That's where we group in our tax guys. Amy, do you have any insight on that?
Tax team, but I will say there are certain situations where the tax policy will dictate perhaps over the particular purchase. So I think in one instance, we, even though there was a demand for continuity of operations because it was a given healthcare provider, a national healthcare provider with multiple states that it was servicing and multiple licenses, the buyer wanted to handle it because of it as an asset purchase, simply because of the tax ramifications.
Saving hundreds of millions of dollars.
Right. So that is certainly an aspect that is brought in and discussed, and the element of consideration. Other questions from the offices or online? Feel free to chime in if you would like. Nothing else?
All right.
All righty.
Well, thank you all.
Thank you, everybody, for attending. We appreciate it. I know it's a lot of ground to cover with a lot of nuances, but again, we appreciate your time and attending the BLT. Thank you all.